pay for someone else's loan. I mean, we could have the conversation about...
There's so many different angles and nuances.
A lot to talk about there,
sure
but this isn't over.
Right.
Meantime, oral arguments for the new Supreme Court term began today. Justice Ketanji Brown Jackson, the first black woman to serve on the Supreme Court, making her debut.
Yeah, after June's momentous decision striking down Roe v. Wade and really kind of remaking the nation's political landscape in the process in many ways, two major cases the court will take up are affirmative action and the way federal elections are held. Joining us now to discuss is distinguished university professor at Touro University, Thane Rosenbaum. Thane, let's dive right in to that affirmative action case. Now, Students for Fair Admissions, Inc. versus President and Fellows of Harvard College. This is really about the definition of affirmative action is the practice or favor or policy of favoring individuals belonging to groups known to have been discriminated against. Previously, the SFFA is asking justices to ban the consideration of race in college admissions. The SFFA is arguing that Harvard and UNC discriminate against Asian American applicants and violate federal law with their race-conscious admissions processes. Now, justices will hear the UNC case beginning at 10 a.m. on October 31st, and the court will hear the Harvard case later that day. Now, Thane, I do want to point out before I get your thoughts on this case that Ketanji Brown Jackson is recusing herself from that Harvard case, so she will not be sitting on that one, but I'll let you take it from here. This is the affirmative action, of course, a hot topic. It continues to be, but we're looking here at Harvard and University of North Carolina.
Katrina, this is a blockbuster. You're talking about 40 years of affirmative action. It was based on the principle of leveling the playing field for minorities and giving them a race-conscious pathway to admission. But guess who's a race as well? Asians, right? The problem is that Asians are being discriminated against through affirmative action. Why? Their test scores and their grade point average are too high. And so that they invariably, fewer of them are admitted to these colleges, Harvard being a private school, University of North Carolina, a public school. And so therefore their argument is that you have violated Title VI of the Civil Rights Act because by theory, the government cannot fund a school that discriminates against the minority. And they're saying, you're discriminating against Asians. So you're violating the Civil Rights Act. The universities are saying, no, 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 no. We're just engaged in affirmative action. We're creating more diversity and more equality of opportunity. But remember, equality of opportunity is what we thought of in the early days of affirmative action. Nowadays, they're talking more about questions of equity, which oftentimes says, in the spirit of equity, you can discriminate against someone in order to create equity for people of color. And Harvard and University of North Carolina are stuck here. They're arguing diversity makes a better campus, and we can't simply have a school filled with high-achieving Asians, even though we recognize that more of them would be admitted if it was purely based on numbers.
Okay. Also, the Supreme Court is going to take up a case from North Carolina that could change federal elections by eliminating virtually all oversight of those elections by state courts. Case is called Moore versus Harper, is a dispute arising from the state's efforts to draw new congressional maps in response to the 2020 census. Doctrine at the heart of the case is known as the independent state legislature theory, the idea that under the Constitution, only the legislature has the power to regulate federal elections without interference from state courts. Proponents of the theory point to the Constitution's elections clause, which gives state legislatures the power to set the times, places, and manner of holding elections and senators and representatives. What are your thoughts on this one?
So, Bob, I don't want to drive you both nuts, but this thing goes right back to the 2020 presidential election. Boom, it's right back there. Why? Because remember, during the pandemic, election rules were changed all over the country. That's why we had so many mail-in absentee ballots.
By courts.
That's why. By courts and state election officials. Courts and state election officials, but not by state legislatures. But what you just read, Bob, says that the founding fathers said in Article 1, Section 4, that when it comes to federal elections, only the state legislatures get to set the rules for time, place, and manner of how these voting procedures are put in place. Yes, there was a pandemic. Yes, there was an emergency. And let me tell you something was interesting, and I said this on Newsmax the day after the election. There was an emergency petition from Pennsylvania to the Supreme Court a week before the election based on this argument, saying, how come we are in Pennsylvania going to allow late arriving ballots after Election Day? And the argument was, well, the Supreme Court of Pennsylvania approved it. And the argument was, but not the state legislature. And Justice Alito said, you know what, maybe we should hear this case. This might blow up in our face one day. Guess what? It blew up in our face, and that's what happened in the 2020 election. There's a lot of people who have questions about the 2020 election. One thing I can say, and I was consistent on Newsmax throughout, this was always standing out there too. This was a problem. The changing in the rules that permitted so many mail-in absentee ballots were not approved by state legislatures.
And actually, out of all the cases that got brought to the courts, that was one that the Trump advocates won.
Exactly. Right. And so it's interesting that that just was murky. There's a lot of things you can say about the election, but there was a constitutional issue, and is that issue.
Yeah.
The Supreme Court is now going to have to decide, do the state legislatures essentially control elections, or is it something that there's the checks and balances among other competing groups?
All right. Thane Rosenbaum, we're going to have to leave it there, but thanks for joining us. As always, great to have you.
Anytime. Thank you.
And coming up,